Welcome everyone, I'm Shirin from Maxwell Chambers. Thank you for joining us for our 5th session of Maxwell Conversations. So today, our guest speakers will speak on the topic, party representation and equal treatment. So before we start, we would also like to thank the following institutions for their support. I would now like to hand over the e-stage to our host and moderator, Lawrence Tay, Global Co-Head of International Arbitration, Dentons. Over to you, Lawrence.
Welcome everyone to Maxwell Conversations, featuring conversations with high-profile international arbitration lawyers on international arbitration topics that challenge assumptions with a deeper examination of the issues. Parties to arbitral proceedings assume without question that they have the right to be represented by persons of their choice. Does such a right exist? And if so, what are its guarantees? Allowing parties a right to choose whomever they wish to represent them may give rise to issues relating to differences in professional and legal traditions, standards of practice, and ultimately, a fair hearing. What laws or standards govern the conduct of party representatives in arbitration? Does an arbitral tribunal, in respecting equal treatment of the parties, have a duty to ensure that each party is represented by party representatives of similar strength, skill, and experience? In this 5th conversation, my guest is Gabrielle Kaufmann-Kohler, well-known international commercial, investment, and sport arbitrator. She's the immediate past president and now honorary president of ICA, the International Council for Commercial Arbitration. She's regularly ranked among the top 10 arbitrators worldwide, and a study of investment arbitration released in 2016 concluded that she was the, quote, most influential arbitrator in the world, unquote. She's Professor Emerita at Geneva University School of Law and is visiting professor on arbitration in several universities around the world. We will later be joined by 2 other guests, Yoshimi Ohara and Mohamed Abdel Wahab, as we go more extensively into party representation and equal treatment. Gabrielle, welcome. We last saw each other a few days ago in Paris, where you received the GAR Lifetime Achievement Award. Perhaps I could start by asking you, what has occupied your time in the last 2 years?
Well, first of all, thanks, Lawrence, for this invitation, and thanks to Maxwell Chambers, and good afternoon or good morning, depending on where everybody is, to all of those who joined this conversation. Except for going to Paris last week and to receive the Lifetime Achievement Award, which was a very nice, rewarding experience, but at the same time, some kind of stressful. What have I been doing lately? Well, I've done some teaching, for instance, at the NUS in February, and Sao Paulo as well, more recently in Paris on Monday. And but I have of course worked on my arbitrations. Well, there's always orders that you have to work on provisional remedies, on bifurcation and the like. And then I'm also finalizing one award and finishing the drafting of another one. So plenty of interesting things.
Do you see an uptick in the number of cases that come across your desk recently, or has that fallen off?
I've seen many. I'm not sure there's an uptick, but I've seen many. I've been approached quite a lot recently, but same thing all through last year. So it's difficult to say whether there's a rise or whether it's always about the same.
Great. Turning to our conversation today, perhaps we could go first to parties' right to representation in international arbitration. I thought I'd ask you, how fundamental do you regard the right of representation to be, and with it, the extent of the freedom of choice of party representative?
It seems to me that this is a fundamental procedural principle. It is part of due process or natural justice or right to be heard, depending on the systems. These rights have different names, but they essentially mean the same. You have the right to present your case and defend your case in arbitration, and part of that is that you could be assisted or represented by the person of your choice. I think that's by now well recognized everywhere. There are restrictions. We can discuss about the restrictions later on. I would say it is a truly transnational principle by now, and is also something that has a real practical significance. It's not only a legal theory or a legal right, but in practice, it does make a difference that one can have the counsel or some other person of her choice assisting and representing a party. We see, of course, in international treaties, we don't see specifically this right being spelled out as such. We see the due process in general. For instance, if you take the New York Convention, you look at the grounds for non-enforcement in 5.1, you would have in B the fact that you were unable to present your case, and that to me would be part of the right of representation would be part of that, but the right of representation as such is not spelled out. There's one exception if you look at treaties, is the Inter-American Convention, but most others do not either have a specific mention. But then you can look at national arbitration laws. Of course, they come into play depending on whenever you have the seat placed in a specific jurisdiction. Some do have it spelled out, others not. The model law, for instance, doesn't have it. And I gather, but I speak under the control of many of you, I gather there's no specific mention either in the Singapore International Arbitration Convention. But of course, there's case law where do you have no, and there's case law in Singapore and many other places that endorse this freedom of choice. The English Arbitration Act, for instance, has a specific reference. And then you can look at the arbitration rules, because if there's silence in the law of the seat, the arbitration law of the seat, then you would look at the applicable institutional rules. If the parties have chosen a rule and they're usually you have a specific mention, look at the SIAC rules, for instance, you would have it, you would have specifically spelled out, and you could mention many others where this is set out. So in summary, a fundamental right of a party that plays an important role in practice.
Do you think the future will see more of an expansion or contraction of these rights? I think you referred to it almost being an international custom or an international tradition, and that probably relates more to legal counsel. But what about non-legal representatives?
Most often there is the right is for a lawyer or a non-lawyer when it is specifically articulated, and that is how it is generally understood. Now, to the question of the expansion, will we see expansion over time? I'm not sure about that. We have seen in the past an expansion of the right. Look, for instance, at the restrictions that existed in a number of jurisdictions for foreign lawyers to represent parties in international arbitration seated in a particular jurisdiction. And we had, there was such a restriction in Singapore, for instance, was the Turner's versus Federal Builders, if I'm not wrong. That was a case in the 80s where the courts ruled out the participation of a New York law firm. And That was, of course, changed. That was based on the Legal Profession Act, and that act was then amended first to allow foreigners to be co-counsel and now to be sole counsel. So that restriction has been overcome, and that is, of course, a sign of expansion. I remember chairing the arbitral tribunal at the Olympic Games in Nagano in 1998, and there I was very concerned because there was the same restriction in Japanese law against foreign lawyers representing parties in international arbitration. We somehow ignored it because we didn't know what to do about it. It was then abolished a number of years later, and we have seen the same evolution in other jurisdictions. So there is this expansion that has been going on. Now, will it continue? Well, where we have restrictions of foreign lawyers remaining in certain countries, probably that will be overturned with time. Whether in general the right of representation will continue to expand, I am not certain, because we also see trends for more regulation, and we see this in decisions where, for instance, counsel have been removed. We see it in a number of soft law instruments that provide for power of the tribunal to regulate conduct of counsel. So there's this expansion going on the one hand, but there's also trends for more regulation and more control over counsel conduct. Does that answer your question?
Yes. What you say brings to mind the very recent announcement of the Bar Council of India, saying that they would not stand in the way of non-Indian qualified lawyers representing parties in international commercial arbitration. So it does look as if there is an expansion, at least in some jurisdictions in Asia. But if I could come back to a topic that we touched very briefly on just a moment ago, who is or can be a party representative? One tends to assume that the party representative would be a lawyer, but would someone who's not legally trained be regarded as a representative that has an equal right to appear before a tribunal?
Yes, in general, that is perfectly admitted. Now, there was also a recent Singapore case that discussed the fact that the CEO of a party would be admitted as counsel. It was not accepted because of the fact that the party had not announced it clearly, and it had also a counsel who was a lawyer. But this is just a factual issue. There was no question that the CEO could not be assisting or representing the party, and in fact, it often happens in arbitrations that as representing the parties, you have a law firm, but then, for instance, in investment arbitration, often you also have government officials that are representing the party. So there's no question about that, that this is acceptable, at least in most jurisdictions, I would say. Now, of course, in practice, it's very rare that you do not have a law firm, and in larger arbitrations, you would have often an international firm that has specific arbitration experience. But that is a matter of practice and efficiency more than one of law.
As an arbitrator, you have heard hundreds of cases, so I feel comfortable in putting this question to you. You've seen counsel conduct, counsel coming from different legal traditions with different standards. Do you feel that the conduct of party representatives in arbitral proceedings, can they be regulated? Should they be regulated?
I remember in 2012, there was the ICA Congress taking place in Singapore. And at the introductory session, there was a striking speech by Sundaresh Menon, who was then Attorney General, and he called for more regulation of arbitration in general, but including of counsel. And I also remember a later speech a few years later by V.K. Raja, who was then the successor of Menon as Attorney General, who also repeated the call for a code of conduct. And there's other voices in favor of a regulation of counsel conduct. But you also hear some people arguing that there is diversity in practices of counsel depending on the home jurisdiction, and therefore you should be careful not to impose a uniform standard. Plus some say we have an overdose of soft law, and so we should not add an additional code. I would distinguish two things. On the one hand, we have national codes or national laws that regulate practice of attorneys, and to which any practicing lawyer is subject in her home jurisdiction. And that applies in any event and is generally mandatory, and there's nothing arbitration people can do about it. Then the question is, do we need something specific for international arbitration? And it is true that in the last decade, I would say, we have, 1 decade, maybe a little bit more, we have seen a wealth of soft law codes of conduct, the IBA guidelines of party representation. The Singapore Institute of Arbitrators also has guidelines. The Spanish Club of Arbitration has the most extensive code I know, not only for counsel, for every actor in the international arbitration process. LCIA has an annex to its rules, was rules on a code of rules on party representation. In investment arbitration, there is the so-called Hague Principles of the International Law Association for counsel appearing before international courts or tribunals. So there is a lot of activity in trying to regulate. Of course, a specific arbitral tribunal could also incorporate rules into its initial procedural documents. I do so often, incorporating the IBA guidelines on party representation in the terms of appointment, terms of reference, or procedural order number 1 if there's no terms of reference. Because that would then, even if it is not binding on the tribunal and on the parties, it signals to the parties that if an issue arises, the tribunal will look at these guidelines as guidance precisely. Now, obviously, all this, the soft law does not apply if either the tribunal, as I just mentioned, has incorporated it or referred to it, or if the parties have not specifically agreed to it, and that. So the question is, should there be something more that is binding and uniform regulation? That is a difficult question. Should you have some kind of an international convention or a transnational code that would still not be binding except if made applicable by the institution or the parties or the tribunal, but would have the advantage of being uniform. Something like last week, the working group 3 of UNCITRAL approved the finalized, not approved, the code of conduct for arbitrators in investment arbitration. Now, would we want something for commercial arbitration for counsel in a similar fashion? It would have the advantage of a uniform regulation. One could, of course, say that we already have that in terms of soft law by way of the IBA guidelines on party representation. They have been, although they're adopted more and more, they have also been criticized as being too American and having been adopted somehow in a haste without a proper public consultation. And so what a new code could bring would precisely be being more global and incorporating more diversity in the rules and more consultation. But I'm not sure I would champion this now as the next important topic for international arbitration, but it's certainly a topic that is out there and may be taken up at some point.
If we could stay on this question of national codes regulating party conduct, it is often said that when parties agree on a place or a seat of arbitration, they are presumed to accept the arbitral laws that are in force in that place or seat. But often there's a debate whether we can stretch that to presuming that the parties also agree to the national codes that regulate party representation. Some think it's a step too far, that presumption is a bit unjustified. Others find no problem with presuming that the parties agree the national codes for party representation. What do you think?
Well, it's a question of what does it mean to choose a seat, right?
Yes.
To me, choosing a seat has 3 consequences. It triggers the application of the seat's law on international arbitration, not of the entirety of the legislation of the seat, because that would somehow defeat the fact of going to international arbitration. So it's really the international law of the seat, and then of course it also triggers the jurisdiction of the local courts for annulment or control of the international arbitration process. And the third and last consequence of the choice of the seat is that it makes it determines the nationality of the award. But beyond that, I think it's a stretch of the mind to think that parties, by setting the seat, make applicable the ethical disciplinary rules that apply to local lawyers. I think the lawyers acting in our international arbitration generally remain governed by their own home jurisdiction ethical rules. That may, of course, create differences between counsel, but then there are also rules of conduct for counsel that derive from the arbitration law. Either there are some specifically of the seat, but otherwise I would say the arbitrators have a duty to protect the integrity of the proceedings. And if a counsel behaves in a way that threatens the integrity, then the arbitral tribunal has the power to take measures to protect the integrity. Now, protect the integrity is not police counsel, it's not punish counsel, it is just making sure that the arbitration can proceed with guaranteeing a fair trial and equal rights for both parties. And that to me is what somehow must will restrict counsel conduct if, for instance, there was the recent case and earlier ones as well, where a new counsel was appointed in the course of the arbitration, which created a conflict with one of the arbitrators. Now, that is an issue for the integrity of the arbitration. And there, for instance, in a decision, it was an AFTA arbitration, but you could very well transpose this to commercial arbitration. There, the tribunal said you have to remove this counts. That was not a question. Sorry, I have to correct myself. That was not a question of conflict of interest. The conflict of interest is an earlier decision. But there was another decision, for instance, where the counsel had acted, had as a prior job, was employed by a third-party funder, by the claimant's third-party funder, and that was that was a member of the council's of the respondents' council team, and there was a risk that this member of the respondents' team had information on the claimant's case from the prior employment, and there the tribunal also said that is a threat to the integrity of the arbitration. That is a risk that the parties do not have equal treatment because one party would know things about the others, about the other party that it would usually not know. So that is, I would say, the framework for ensuring that counsel conduct can be somehow controlled.
You've also touched on the soft laws out there on regulation of party representation and the support for and criticisms leveled against things like the IBA guidelines. Might there be a third way of introducing some regulation of party representation? And my question is whether arbitral institutions have a role to play in publishing codes of conduct such that when parties select the procedural laws, they also select codes of conduct. What do you think?
Yeah, I think that is, of course, an efficient way of doing it. The LCIA has done it. It has an Annex A on party representation in an annex to its rules. So if you choose LCIA arbitration, you necessarily submit to these rules. The ICC recommends that you apply the IBA guidelines, but that's just a recommendation, so it's not as strong as it is. I have asked myself whether, because I see the value of some kind of a uniform regulation, whether, for instance, institutions could not sit together and work out an annex that would be a uniform annex and then make it applicable to their rules separately, or some mechanism like that might be useful.
Thank you. Ladies and gentlemen, we are now joined by two other guests. The first is Yoshimi Ohara, a partner at the Japanese law firm Nagashima, Ohno, and Tsunematsu, who practices in international arbitration, international complex litigation, and mediation, and she also sits as an arbitrator. She has contributed to shaping soft law in international arbitration through her participation in the activities of the IBA, the International Bar Association. The second is Mohamed S. Abdel Wahab, founding partner and head of international arbitration, construction, and energy at Egyptian firm Zulficar and Partners. Among his many achievements, he is professor of international arbitration, private international law, and English contract law at Cairo University, ICA treasurer and member of the governing board of ICA, president-elect of the Chartered Institute of Arbitrators, and current co-chair of the IBA's Arab Regional Forum. In addition to practice as counsel in arbitration, he serves as arbitrator and expert witness on many laws of the Middle East. Yoshimi and Mohamed, welcome.
Thank you very much, Lawrence. It's a pleasure to join you today alongside Professor Gabrielle Kaufmann-Kohler, of course.
Mohamed, perhaps I could start with you and ask you that while there may be general agreement that a party representative should not make any knowingly false submission of fact to the tribunal, is there difficulty with this, with the application of this principle? Must a submission, for example, be supported or referenced in the evidence before it can be made?
Thank you very much, Lawrence. I was listening with attentively and delighted to hear Professor Kaufmann-Kohler on the topic, and I'm sure Yoshimi will have her views as well. Let me start by saying it is a very interesting topic because, as we say, the devil lies in the details. While there is consensus that no one should knowingly make false submissions, it is interesting because it involves an element of intent, the knowing part, which is to an extent subjective. How can you measure it? And then what would constitute really a false submission? And in addition to that, international arbitration by definition is inherently multicultural. And there are many rules at play, people from different backgrounds. Just to give an example, if you are in an English law-governed arbitration or seated in England, making an allegation of misrepresentation or forgery is a very serious allegation that would not be made by counsel unless supported more or less by compelling evidence. Whereas if you go to other parts of the world, potentially in certain parts of the MENA region or other parts on the African continent, and in certainly some parts as well in different regions of the world, people sometimes feel that it is fine to make an allegation of that sort without any support whatsoever, without fear of reprimand or being penalized for that. And they say that it is part of the right of defense to run arguments like that, and then the tribunal can consider or refuse to do so. And that creates an uneven playing field in a way, because sometimes counsel is bound by strict bar rules and others do not have as strict rules as we see. And that has led the community to try and develop some soft law instruments, which Gabrielle has very kindly mentioned, including the annex to the LCIA rules and the IBA guidelines on party representation, as well as the Spanish Club, the Singapore and the Hague Principles. But there's also recently the ICA report number 9 on the guidelines on the standard of practice, which does include under standard 2C a specific reference to the point you make. And I think within the arbitration community, when you have counsel who is well-versed in the intricacies of international arbitration, they would normally be expected and they would behave. The issue is sometimes you may have newcomers or people who practice domestic litigation in some distant localities who may not be bound by the same rules or feel that they subscribe to that club in a way. So, as you say, making arguments of that sort, one expects that to be supported by evidence, but the reality is it's not always the case. And how can we reach a common denominator of principles that can effectively and pragmatically be applied? And what penalties, if any, could be applied? I mean, one thing, for example, under the LCIA annex, as Gabrielle has mentioned, which if the parties agree, it forms part of their agreement, the tribunal may theoretically have the possibility of excluding counsel. I have not come across a case where the tribunal has excluded counsel on the basis of this type of misconduct. I've seen cases where counsel has not been admitted on record to avoid conflict of interest to protect the integrity. but I haven't seen it exercised in that sense. And there is possibly a reason, because counsel could be coming from a different jurisdiction. And so a tribunal taking a step like that may lead to a situation where the seat of arbitration could be in a different jurisdiction, and the courts would say a party is entitled to their counsel. You have other measures at hand, including allocation of costs, including rendering decisions or directions on matters of procedure. So it is interesting to see how practically we can apply that standard and ensure there is a commonality as to not just the understanding and acceptance of the general principle, but in practice, how we can apply it. And I think the way possibly is to identify specific scenarios or situations where that principle would come into play. And as Gabrielle has mentioned, either in terms of reference or in another document that the parties sign, they may subscribe to that. The difficulty sometimes, like with the IBA guidelines on party representation, is that not all parties in different jurisdictions accept it. I've seen counsel saying, well, we don't need it. We will behave, but we don't need it. So there is a limit to what the tribunal can do, but the reality remains that it is one area where much work remains to be done, more consensus is needed, and more civility is required by all participants in the process.
Yoshimi, could I invite you to comment on this topic and perhaps take Mohamed up on his suggestion that there could be illustrated examples to aid parties in understanding what is required of counsel conduct?
Thank you, Lawrence, for your kind invitation, and thank you, Mohamed, for your wonderful presentation. If I may, I would be happy to share, and I may not be directly responding to Lawrence's point, but I'd be happy to share my experience being part of the process of putting together this IBA guidelines on party representation, because I think it's worth sharing. As you know, it was really difficult process. We have a number of discussions. The lawyers from various parts of the world joined the discussions to come to consensus as to what needs to be included in the IBA guidelines on party representations. And as Mohamed mentioned, there are diverse views as to what should be included and what should not be included. So as you can see from the IBA guidelines on party representation, so talking about forced submission of facts, so such forced submission of facts, knowingly, parties' representation should not make any knowingly forced submission of facts to arbitral tribunal. There's a serious discussions as to what about the law, wrong submission of law. In some jurisdiction that is against the code of conduct. In some jurisdiction, whereas so it was really difficult for representatives from various jurisdictions to agree on the guidelines, the specific terms and specific content of the guidelines on party representation. And what we found in the IBA guidelines on party representation is the best practice at that time that can be accepted from counsel from different jurisdictions who are subject to different home code of conduct in home jurisdictions. So I would like to echo what Professor Gabrielle Kaufmann-Kohler mentioned, and also Mohamed Abdel mentioned. I think it is important to introduce a mechanism where this, some code of conduct can be actually implemented in arbitration proceeding, ideally automatically. And one way to achieve that is to, as has been already alluded or mentioned, it makes sense to have some sort of guidelines to be part of the institutional rules. That is my comment to the issue, Lawrence, you just pointed out.
Thank you. Gabrielle, Mohamed made an interesting comment that sometimes parties are represented by counsel who either don't do arbitration or don't regularly do arbitration. They don't feel they belong to a club, and by that extent, they don't subscribe to the customs or the practices of the International Arbitration Bar, if there was one, and they reject any form of regulation. What would you do in a situation like that, where counsel says they don't feel that they're bound by any soft law or international norm?
Well, first of all, thanks to Mohamed for mentioning the ICA standards of practice. I should not have forgotten them. And actually, sometimes when parties refuse the IBA guidelines on party representations, they may be more willing to accept the ICA standards, because the ICA standards are more limited and somehow, you would say, less detailed, more general in nature, and therefore more acceptable. And nevertheless, the main rules are there. If the parties don't accept that some guidelines are applied, then there's always, the fallback position is always that the tribunal has inherent powers to regulate the conduct of the arbitration. And I don't think that is seriously challenged by anyone. It is a power that national courts have, that international courts have, and that arbitral tribunals also have. It is based generally on the residual procedural powers. That is not a power to sanction, it's just a power to make sure that the arbitration can be conducted smoothly. And that is the fallback if there is no other solution. Of course, when you then exercise this power, you would, for inspiration, look at different soft laws, but so they would, even though they're not strictly speaking applicable because they're not agreed, they would still play a role.
Thank you. Yoshimi, there is a variance internationally on what conduct is appropriate when approaching and preparing witnesses. Some will regard it as inappropriate that the party representatives on one side approach a witness that appears to be associated with the other side. Others regard it as inappropriate that any witness be coached on what to say. Where do you think the limits lie in international arbitration?
Thank you, Lawrence. I shall start with I think you made a two question. One is approaching a potential witness who's supposed to be on the adverse party side. And second question is to what extent you can prep your witness. So I would first start with the initial question, which is, would it be appropriate to reach out a potential witness, which seems to be on the adverse side? And well, I've given this question about a month ago, or less than a month ago, and I have looked into this issue, but unfortunately, I wasn't able to locate a good, commentary or interesting court decisions on this issue. Perhaps this is because, this issue doesn't really become surface because this, approaching a potential witness who is on the, adverse party has been done not openly, in a transparent manner, and therefore this issue perhaps didn't surface, and perhaps that is the reason why there haven't been many, discussions on this issue. But what I can say from the material that I have looked into, there is a sort of common ground, or generally accepted code of conduct in various jurisdictions. That is, counsel is prohibited from approaching an adverse party when adverse party is represented by counsel. Such direct communication with adverse party when they are represented by counsel without, obtaining prior consent from counsel is prohibited. And I think, it is what such code of conduct is widely accepted. And the reason why these, such code of conduct is widely accepted is because directly approaching adverse party when adverse party is represented by counsel is essentially, it's interfering the relationship between counsel and such adverse party. And also, it's defeat the whole purpose of, of adverse party retaining his or her own counsel. Then the question is whether this, commonly accepted code of conduct can be translated into a rule or code of conduct in terms of whether counsel can approach a potential witness on the side of adverse party. I think the reaction to this question are quite diverse depending on jurisdictions. As Lawrence mentioned, some jurisdiction, as Lawrence also, guidedly, you mentioned that witness is not anyone's property. Essentially, witness is to be there to be snatched by counsel for either party. So that is one of the extreme approach. And the other extreme approach is based on the commonly accepted conduct that, once a party is represented by counsel, you are not supposed to directly communicate with such adverse party, and extending such way of thinking and counsel in certain jurisdictions either prohibited from approaching senior management of adverse party directly for the potential witness opportunity. And even if it is not regulated or prohibited by code of conduct, lawyers in some jurisdictions become very conservative when it comes to approaching potential witness on the side of the adverse party when adverse party is represented by counsel. So I think again, there's a value of code of conduct that applies to international arbitration in general, because counsel to parties, counsel may wonder whether he or she remain to be subject to code of conduct in home jurisdiction, or he or she will also, in addition to the code of conduct in home jurisdiction, will be subject to code of conduct of the seat. So precisely because of that questions surrounding code of conduct in terms of the content and the way of enforcement of such code of conduct, IBA put together this, guidelines back in 2013. And I think, this guideline is helpful in a sense that it put together best practice that can be acceptable to, parties from different jurisdictions. And according to the IBA guideline on party representation, the guideline 18 and 19 actually address that issue. So clearly, guideline anticipates or accepts counsel can accept that, counsel can approach a potential witness on the adverse party, even if the adverse party is represented by counsel. But there are certain, rules that should be complied. That is, when you're approaching, you have to identify yourself. And then you also identify yourself that you are a counsel of your adverse party. And also the reason why you're approaching that person means, I'm actually approaching you for a potential witness opportunity. So that kind of disclosure has to be made so that, integrity of the process can be maintained.
Thank you. Gabrielle, can I ask you for a quick comment on this topic, followed quickly by Mohamed? Any quick thoughts that you might have on approaching witnesses and coaching of witnesses?
Yes. On maybe coaching of witnesses is easier. I remember many years ago, I had been trained in New York. I came back to Switzerland and practiced international arbitration. And I knew, of course, that in Swiss courts, counsel cannot speak to witnesses. But it didn't occur to me that one could think that this would apply in an international arbitration seated in Switzerland. So, of course, I prepared the witnesses, and suddenly during their hearing, the adverse counsel says, well, these witnesses seem to remember everything and they answer every question. I think they have been prepared. And this was for this counsel just totally unacceptable. Now, this was almost 40 years ago, and things have changed now because I think today everybody accepts that counsel can be prepared. And in that sense, there's been a strong convergence in the way witness examinations are conducted, and the very fact that you have witness statements necessarily means that you will have a contact between the witness and counsel. Now, of course, how far can you go preparing witnesses? That is a more difficult question. The limit is falsehood. No influence to say not to influence the witness in such a way that she says things that are not in her knowledge of the facts. These are the limits. How you enforce them is a more difficult question, but you can, if in the witness statements, for instance, you have things that are not really the witness's evidence, you will find out in cross-examination. And if you don't find out in cross-examination, the arbitrators will ask questions and it may well come out. And so you better not go there. Approaching a witness of the other side. When I have a question like this, I always try to think, what are the rules, right? Okay, there's nothing written about this specifically, but we are not operating in a vacuum. There's the international law of the seat. Does that have rules that could apply to this? I am not sure, because you could say, well, you interfere with the due process rights of the other side to present its case by approaching a person that's close to that other side, but you can also say, well, it's my due process right to make my case, and therefore I need to be able to produce the evidence. So maybe that doesn't help much. And then I'm looking for a reason why you could not seek the testimony of someone who's close to the other side, and I don't really find one. It's a different question than to see how do you go about it. Can you approach the witness directly? If there is counsel, I would say for reasons of courtesy or for reasons of collegiality, you would probably go through counsel. If counsel then says, no, you cannot approach this person, then you can always ask the tribunal to allow you to do it, or to summon the witness as a tribunal. So that is how I would approach this part.
Thank you. Mohamed?
Yes, just very briefly, I'm very grateful for Yoshimi's very helpful and excellent comments, and Gabrielle's spot-on comments. Very briefly, I will say the following. Well, we know that at least the IBA rules on taking of evidence, Article 4.3 refers to interviewing and discussing things with the witness. It doesn't talk about influence, of course, but then discussion is a gray area, because through discussion, you can seed in some thoughts, you can question points, you can actually, if the witness is their first time to testify in an arbitration, they need guidance. So through guidance, you may use this as a backdoor in a way. That's not encouraging this practice at all, but I'm simply saying that practically it may happen. But Gabrielle's point is right, because it will come out in cross-examination. No matter how you prepare the witness or how good the witness is, if you've got a good cross-examiner, it will come out. And the witness cannot help, even if they are trained or whatever you've done with them. At the end of the day, their personality will come out at one point. They will just be themselves at one point of time, which makes it a very interesting exercise. But let me share with you, and that's why I think sometimes it's more of a storm in a teacup, because the reality is tribunals can read witnesses, parties can, but one important cautionary point, we should be aware of the cultural differences. For example, some witnesses coming from certain Asian countries, and I would like to say Japan, for example, it could be impolite for them to say no. So they may disagree, but they just don't say outright, no, I disagree. And so tribunals need to understand the cultural nuances there because they are at play and they are human beings and they are not part of the war that is going on between the parties and counsel in an arbitration. So that's interesting. But let me share with you one interesting story that I faced. I was presiding a tribunal where one party submitted a witness statement. In the next round of submission, that very witness submitted a second witness statement for the other side. So one side submitted it, and then it became an issue, who's going to call the witness? And ultimately, following a debate and the tribunal rendering a procedural order, the parties have come to agree that both statements cancel each other and no one is going to call the witness. But for me, it was interesting because it was the first time to see a witness submitting a written statement for both sides opposing each other. So anyway, I think at least for many parts of the world, it is not uncommon that you approach a witness who's an employee of the other side, or even an employee who has actually been let go. And you can see sometimes that there is a grudge because they are trying to have a comeback. And I've seen that in a Geneva-seated arbitration. Anyway.
We might yet come back to Mohamed's point on cultural differences, but I'd like to ask finally, Gabrielle, if you should be in a situation where as an arbitrator, you find that one party is represented by a very large, very skilled and very experienced international law firm, and the other side is represented by a small, unskilled and inexperienced provincial law firm, do you regard it as part of your duty to do what you feel is necessary to ensure an even playing field? And if so, what steps might you take?
Yes, that's a really difficult question. And I never really know how to go about it. It does happen. It does happen. And one, as a tribunal, you would wish to help the party that is poorly represented to kind of level the playing field. At the same time, you have to be very careful not to appear biased in favor of that party and not to somehow then jeopardize the appearance of impartiality, which would then, could risk disqualification requests, but more importantly, could risk weakening the award in the end. So there is a delicate balance. What I would say is if a party has not raised legal arguments that I feel as a tribunal I need to review to get when I give the award, then I would raise it. Certainly, I would not raise it to that party. I would just ask both parties to comment. And I would probably do the same with respect to facts, because I would ask questions of fact that to a witness, for instance, that a counsel may not have asked and should have asked. But then if she doesn't do it, then I think I should do it because it's my duty to establish the facts. And that may somehow level the playing field, although it will never be entirely level. And then in life, we're all different. There are inequalities. I don't think it's for arbitrators to try and make everything equal. It's just an impossible task.
And Yoshimi, your perspective on this scenario, how would you approach it?
Yes, I entirely agree with, what Gabrielle has mentioned. It is really difficult, you want to treat parties equally, but without assisting a party which is represented by a less sophisticated party, tribunal will not get the answer, will not be able to make decision. So to the extent tribunal needs to collect information so that tribunal can make the proper ruling. As Gabrielle mentioned, I think, tribunal should be able to, sort of supplement questions to parties. But it is, I think, to what extent such approach can be permitted also depends on jurisdiction. Some jurisdiction, tribunal is permitted to ask question of law to parties, even when parties are not making that question, making that submission. So I guess, you may wish to take a look at the role of the seat as to what extent tribunal can intervene.
And Mohamed, perhaps I could put the same question to you in a different way. Ought tribunals to be an inert umpire, which is more favored in the common law tradition, or in such situations should tribunals think about exercising more of their inquisitorial powers to even the playing field?
Thank you very much. Again, it's a very controversial and interesting question. And there is no one right answer, but I will say the following. If we go back to the principles, what is the role of the tribunal? You're there to investigate the facts and decide the case in light of what has been presented to you in that sense. You're not there to aid one party, as Yoshimi has mentioned, and I think Gabrielle has also alluded to that. And so a party is entirely within their rights to appoint counsel of their choice. And people are different. And so the reality is what the tribunal is there. Now we're talking about different capabilities, different skill sets. And that's the reality and the beauty of it, I have to say. Now, tribunals are there are not to make a case on behalf of a party. For example, if the tribunal has, strong background in the law applicable to the case, and there's, for example, a limitation period argument that has not been run. It's not for the tribunal to make it, because that could be a killer to the whole case in a way, and it's for the council to raise it. But Yoshimi as well is right to look at what the law requires. And I know it's not the topic for today, but this is also on the borderline of Jura Novit Kuria, which is a very controversial topic in many jurisdictions. And so we have to be careful how to deal with the matter. And I think it's one of the pet topics that I like, setting it in the beginning, what the tribunal is expected to do is important. And I think for example, the LCIA rules have included rules about ascertaining the content of the applicable law, for example. How do you go about doing it? In PO1, we rarely see references to how the parties intend to plead their cases, or the applicable law. Is it by way of expert evidence, by way of submissions? And the facts, Gabrielle is absolutely right. If the tribunal finds that there are certain material and relevant facts that need to be ascertained, we ask questions. But when you ask questions, you have to be careful not to cross the line. Now, of course, the line is different in many cultures. And that makes it very interesting when you sit with colleagues from different backgrounds and different jurisdictions. But I guess it's going to be a hot topic that we always, behind closed doors during deliberations or in arbitrations, grapple with. And I think with a good presiding arbitrator in place, consensus can be reached. But sometimes people go rogue. I've had a case where we had a Swiss president, the applicable law was UAE law, and the party has run the case on the basis of force majeure, not exceptional circumstances, which to us it could be a clear case of exceptional circumstances, imprévision, but they chose force majeure, which is a higher hurdle of impossibility. They didn't. And the arbitrator appointed by that side said, what about that imprévision thing? I said, well, it's not part of the case. We can't have a new case in the hearing. And we agreed not to raise it. He raised it. And counsel said, no, that's not our case. So it was at least good for us. And ultimately, he even dissented on it, despite the fact that counsel did not run the argument. But we could have had a situation where counsel would have latched to this, and we'd have then a dispute about whether this is appropriate or not. Anyway, war stories.
Thank you, Mohamed, for that spirited account. We now come to the question and answer part of this event. If you have a question you would like us to consider for answer, you may use the Q&A function to pose it. While the questions are coming in, and we have dealt with uneven playing fields, perhaps I can ask the panel that we have often heard references to, quote, guerrilla tactics, unquote, in international arbitration. Where do you draw the line between strategic and tactical conduct and guerrilla tactics? And once the line is crossed, would you consider a complaint to the arbitral institution, the national regulatory body of the party representative, or some other authority on the basis that the party representative has caused or induced a breach of procedural good faith in the arbitration agreement? Perhaps we could start with Gabrielle.
Yes. Well, you see parties who are more active procedurally and send you letters with objections and issues every week, and then it makes it very heavy for everyone to deal with it, but you have to deal with it. Sometimes you can say from now on, no unsolicited letters unless you explain to me why you have to make a certain request, and then the tribunal will allow it or not. Sometimes you cannot. It all depends on the case. In general, I mean, there's a lot of talk about guerrilla tactics. I'm not sure a good tribunal cannot channel the proceeding in such a way that you simply continue on track and not get off track. Now, what about a complaint to some external body? Well, I've certainly never seen a situation like this. I I'm not saying I would never do it. It depends, maybe, but I would be extremely hesitant and reluctant to file a complaint against counsel, because I really think it would interfere with the perception of my independence and impartiality, and I would then be seen as being in conflict with a counsel, and that to me could be a ground for disqualification. I think the tribunal should remain above the crowd and just go on and resolve the dispute, because that's its job, and the rest is skirmishes.
Yoshimi?
Yes, thank you. Well, thankfully, I haven't been, subject to such guerrilla tactics in the past. So not that, serious guerrilla tactics in the past. So I may not be the right person to answer to your question. But what I would say to your question is that, as Gabrielle mentioned, we should deal with those tactics based on whatever tools you already have, rather than, exhorting to institution outside the arbitration proceeding itself, because tribunal has power to deal with such guerrilla tactics. And one of the, tool is like, cost consequence. And also, one of the guerrilla tactics could be like, numerous challenges to arbitrators, constant challenges to arbitrator to disrupt the proceedings. Or, constant challenges based on no ground for challenges. For these challenges, I guess, institution, not the tribunal, can properly handle. Again, there should be cost consequence. So to put it in short, I think the tribunal and institutions has many ways to handle it. Thank you.
And no stranger to guerrilla tactics, I'm sure, is Mohamed. Your perspective, please.
Well, yeah, in dealing with them, not using them, I have to say. But let me say the following. I fully agree with what Gabrielle and Yoshimi have mentioned. And I will just add the following. Advice to counsel. Pick your fights to be taken seriously by tribunals. Counsel need not fight over everything, really. And if you're talking about, and I think your excellent question, Lawrence, is framing it as strategic or guerrilla tactics. I think they are worlds apart. Strategic means you're looking at the aims and interests of your client. And that requires you to take a measured, reasonable, intelligent approach to the request that you make without abuse and with the appropriate decorum. Guerrilla tactics lacks at least two, if not all of these. And to that extent, you can see the dividing line. Now, of course, sometimes counsel, again, culturally come from different backgrounds, and arbitrators can understand the context. And I think arbitrators who practice internationally and have that international outlook can indeed avoid escalation early on by giving the confidence to the parties and the counsel that they are impartial and independent. And my final point is that I fully agree with Gabrielle that I wouldn't, and I don't expect that you would report to authorities and stuff, because then you become in direct conflict with the counsel, where you have other tools to use in a way. So that's it, but I think it's a very fair point. I think this is a very rich area for further, not just guidelines, practical applications and scenarios to consider.
Thank you. One of the questions that's come in deals with a situation where there's more than one code of conduct applicable. And the question is whether tribunals should adopt a cumulative approach in the sense that all counsel should conform to all codes in play. Perhaps since we just heard from Mohamed, you could continue and address that question, and then I'll ask Yoshimi and Gabrielle.
Well, to use a conflict of laws approach and analysis to it, if we have competing norms or laws and they are not consistent with each other, so you can't apply a cumulative then application because they are, different. If they are different, you apply the strictest. But then the question becomes, what would constitute the strictest rule? And I think we face that even with rules on privilege. What rules govern if you have different rules in that sense? I think the best way is to avoid that side dispute about what procedure rules and stuff, and agree with the parties about a common approach to things. Just as much as we talk about, for example, the burden of proof on the substance. Would you go with a balance of probabilities, beyond reasonable doubt, whatever? And if the parties reach a consensus about a common denominator of rules that apply, that would be ideal. If not, the tribunal has to set it, taking into consideration at least the rules prevailing at the seat and the applicable law, unless the tribunal is aware that there is one place of enforcement, which I think is a more theoretical one than anything else.
Yoshimi, would you agree with that? That there should be the tribunal should endeavor to obtain party agreement on one code?
Tribunal should not obtain one agreed code. I think, first of all, there will be multiple code of conduct inevitably applies, because each council is subject to code of conduct of home jurisdiction. In many cases, those code of conduct of home jurisdiction applies even when you are practicing outside of your jurisdiction. So inevitably, inconsistency or conflict of multiple code of conduct occurs. Talking about code of conduct or soft law, I think it's at least better for the parties to agree, or at least better for the tribunal to give one direction, which is at least simplified issues, because in any event, code of conduct of home jurisdiction applies in cumulative way, and therefore the tribunal should set simple, clear guidance if at all possible. And if there are disagreement between the parties, such disagreement should be identified by the parties, and the tribunal should set the clear guidance as to the points where parties disagree. That is my view, if at all possible.
And Gabrielle.
Yes, no, I can only repeat what has already been said. If a council is admitted in two jurisdictions to practice, then she will be subject to the codes of these two jurisdictions. That there's nothing the arbitrators can do about that. And but however, for purposes of the arbitration itself, it would indeed be preferable to have specific guidelines that are well identified if you have them, and otherwise the tribunal will have to deal with whatever it considers necessary to protect the arbitration. That's it. Yeah.
Gabrielle, another interesting question that has come in, and I think this question focuses more on the equal treatment part of this event, has the universal shift to virtual and hybrid arbitral hearings created new issues and problems around party representation, and in particular, equal treatment? We all have experienced a virtual or indeed a hybrid hearing at some stage. Do you think that produces new issues?
It certainly produces the issue of time zones. Because if you have people in Japan, as I had some time ago, and others in the US, some will have to cross-examine in the middle of the night, depending on how you structure the hearing. So and that's an equal treatment issue, I would say. You have to make sure that you organize the hearing in such fashion that everybody still proceeds during decent hours, which will mean probably shorter daily hearings and more days. But that is a practical matter that can be easily dealt with, but it has to be kept in mind. I also thought that in terms of threats to the integrity of the proceedings, serious precautions need to be taken to when you hear witnesses or experts that you're not in front of you, so you don't really know in what environment they are, who's wisdom in the room, who's somehow holding signs like say no. All of this can be controlled. You have to make sure that you see the entire room. You have that there's no one else in the room and the like. But it has to be specifically spelled out in a protocol and then enforced during the hearing by the tribunal.
Thank you. Yoshimi, perhaps I can ask the same question in a different way. Do you feel that something is lost when, say, a witness from East Asia gives evidence to an international tribunal that might be gained in a physical hearing?
Yes, of course. Well, thank you very much. You know, I entirely agree with, you know, what has been said by Gabrielle. You know, we are suffering from time zone issues seriously. We, you know, generally start, you know, arbitration hearing, you know, at either, you know, early evening or late evening or midnight. That's the choice given to us almost all the time. So that is a challenge to our witnesses. And also, you know, witness demeanor cannot be clearly presented through virtual setting. And now that, you know, in my experience, hearing are going back to live in many cases, I, you know, confirm the importance of, you know, presenting witness physically rather than through online. So I think it's not necessarily limiting to witnesses in you know, Asian party, where demeanors tend to be much more milder or softer or subtle and harder to send a message to the tribunal. But it equally applies to anyone who appear in front of the tribunal. And I'm curious to hear, you know, Mohamed view as to the impression of the tribunal of the witnesses between, you know, when witnesses are presented live or witnesses are presented online.
Mohamed, I did say that we might come back to cultural differences, and here's your chance. Equal treatment, cultural differences, and Yoshimi also mentioned the loss of sensitivity in detecting demeanor. What do you say?
Again, I am very grateful for Yoshimi and Gabrielle's points there, and I fully agree. On the time zone one, let me start in order. I fully agree to the point, and that's why, at least when I sit as an arbitrator or preside, I take it upon me to do that. I've had parties from the US, in a case California and Korea, and I started the hearing for 5 days, 1 a.m. my time, because I wanted counsel to have their time without coming in the middle of the night. That, of course, was facilitated because one arbitrator was a prominent US professor, another very prominent Korean arbitrator. So the one that took this on board, and gladly I suggested it, which is a quiet time at my end as well. And it worked perfectly to ensure that counsel get their time they need, which leads to shorter hearing times, as Gabrielle has mentioned. But in addition to that, as Yoshimi has mentioned, it is very interesting, and I think we need psychological studies, because I started since COVID monitoring how witnesses behave. When the witness is in a hearing room and everyone is looking at them with an attention, focus, they are tense somehow, they are measured, they are not comfortable. You try to make it easy for them, of course. But when they are sitting at home or in a location with which they're familiar, they are more courageous. They are less intimidated by counsel. They don't feel that they are within the counsel's grab. Now, the question is, does that make cross-examination less effective? Some counsels suggest that it is the case. Others say, no, we will deal with it as and when it happens. So there are different schools, but indeed, it is interesting because the behavior of witnesses is not the same online and in person physically. I'm not suggesting about the content. It's simply the feeling they have in a setting with which they're comfortable online compared to anything else, which also makes it possible. I think with the use of technology, you can detect facial expression, stuff like that. But the reality is then you're sitting with a number of screens, which becomes very complicated. The last thing I will throw into the mix about what changed, in addition to time zones, I see that party representation could also be affected by access to technology. A seamless internet connection on the part of one side counsel to present the case seamlessly, no technical issues. And on the other side, a party which does not have access to internet, and I've seen that sometimes with counsel from African jurisdictions and Middle Eastern jurisdictions where the connection is not as good. And then they are frustrated, the tribunal is frustrated, and that humanely affects perception. Now, whether you become sympathetic or not is another, well, it's a function of how you as an arbitrator consider things. But sympathy doesn't add much, because at the end of the day, you would like to hear their submissions and get it right. So technology does add a layer of complexity if there is an uneven access to technology there.
The point that Mohamed has just made was covered to some extent in the very first Maxwell conversation featuring Lucy Reed as our arbitration personality. The theme was the right to a physical hearing, and that can be viewed as a video on the Maxwell Chambers website. I have one final question that has come in that I think is interesting. We might have covered this ground, but it's worth us revisiting this question again. If you will give me one brief moment. And it is this: when a tribunal has realized that one party to the case has used some unacceptable practices, how will the tribunal deal with such a situation so as to make the other party not lose their position based on this? Yoshimi, would you like to lead us on this question, on the answer to this question?
Sorry, the question is when counsel engage in misconduct,
yes.
And then
if you're an arbitrator and you realize that one party is using unacceptable practices, how would you deal with that kind of situation and ensure that the other party suffering the injustice doesn't lose any position based on it?
Well, it's really hard to make a general statement. It all depends on the level of misconduct and the impact and prejudice to be given to the opposing party. So, so there's no general answer to the question, but the tribunal should at least point out the inappropriate conduct on one party to, first of all, make sure there will be no repetition of such misconduct. And if there's any harm to be given to the other side, tribunal, of course, first the tribunal should wait for the application for the party who is affected by misconduct. But depending on the application, tribunal should address and provide remedy to the affected parties. Without, having specific setting, it's hard to give specific answers, but that's what the tribunal should do.
Mohamed, can I invite your take on it before giving Gabrielle the right of final say?
Well, briefly, sometimes parties and counsel test tribunals to see whether they will be decisive or not. And I think tribunals need to be decisive without rushing into making decisions that are not thought through. So being decisive is good, but at the same time, being measured in your responses. Remember that tribunals should not descend into a fight with the parties, but at the same time, they should give them the trust and confidence. And if one party is not behaving with the appropriate decorum or has done a misconduct, one thing, I think this should be brought to that party's attention in an objective way. Maybe that party is not aware of that situation. I mean, you give the benefit of the doubt first time and suggest that this is how things are expected to proceed so that the rules are clear. And if they don't, then you refer the parties to the point that the tribunal is in control of the proceedings, will make directions, and is entitled to consider the parties' conduct when allocating costs. You make that in a neutral way so that the parties are aware. And at the same time, when you take decisions procedurally, it will become clear that the tribunal is not going to be intimidated, threatened, or buy into that stuff, which can give the needed comfort to the other side. And if the other party continues to misbehave, then they are doing a disservice to their client.
And Gabrielle, finally.
Yeah, I again agree with what Yoshimi and Mohamed said. It's difficult to give a general answer without being knowing what the specific circumstances are. I know that, for instance, and it is right that the reaction will probably be different if the misconduct is deliberate or not. It may just also be a question of ignorance that things are usually done this way. And then I would try to make sure that the counsel who has made the mistake would be able to save face. And so one way of doing it is, for instance, if it happens during a hearing, you could take the two lead counsel aside with the tribunal and say, listen, I think this is occurring, this should not, can you please make sure it stops or so, and then it goes away and nobody feels offended, and it's easy. There are other situations where, of course, it cannot be done like this, and it requires some kind of procedural intervention, a procedural order, or just a letter saying this is how our things are done, and from now on, please comply. It's all a question of how do you best deal with the fact that you need the cooperation of counsel to continue the arbitration. You're not a national judge who has the authority of the states behind. You really need the cooperation. And at the same time, you have to ensure a fair process, and you try and balance this the best you can, depending on the circumstances.
Super. Ladies and gentlemen, I hope you enjoyed this Maxwell conversation. Watch out for our next Maxwell conversation, where we deal with another topic and challenge assumptions with a deeper examination of issues. It remains for me to thank our speakers, Gabrielle Kaufmann-Kohler, Yoshimi Ohara, and Mohamed S. Abdel Wahab, and for me to wish you a very good day from wherever you're watching. Good day.
Thank you. Goodbye.